Welcome to the webinar for this morning, Family Court Enhancement Project, Reflections from Cook County. My name is Amanda Kay with the National Council of Juvenile and Family Court Judges. Before we begin, I'll give you a brief overview of the webinar system and how you can interact with today's presenters. Just below the attendees list, you'll see a chat box. Within this window, you'll be able to send messages to the other participants in the webinar. Chats entered in the Everyone tab will be stored and may be posted online as part of the recording of this webinar. To chat, simply type your message into the white field at the bottom of the window and press Enter on your keyboard or click the button to the right to send it. On the right side of the screen, you will see a list of materials related to today's presentation. To download them, simply select the files you desire and click the Download File button. A new browser window will open, confirming that you wish to download the selected file. Once you confirm, your download will begin. At the conclusion of the webinar, a survey will appear on your screen asking you to provide feedback on how we did today. We encourage you to take the time to complete this survey as it helps us determine how we can improve future webinars. Please remain in the webinar until the survey appears on your screen. The link to the survey is also available on the right side of the screen just above the materials box. To begin today's presentation, I'd like to introduce our presenters. Judge Sebastian Patty, presiding judge of the Cook County Domestic Violence Division, and Leslie Landis, Family Court Enhancement Project Coordinator and Court Administrator.
Good morning, everyone.
Good morning. For the first few minutes, I'm just going to give an overview of the project. At the conclusion of the presentation, participants will be better able to describe the purpose of the Family Court Enhancement Project, describe the importance of court and community readiness for undertaking this work, and identify the steps that can be undertaken for system assessment and improvement in your own jurisdiction. The goal of the Family Court Enhancement Project is to improve the family court response to divorce and parenting cases involving domestic violence so that resulting parenting arrangements protect the emotional and physical well-being of victimized parents and their children. We know that custody in domestic violence cases is a problem. Different studies have resulted in findings that anywhere from 1/4 to 3/4 of disputed custody cases involve domestic violence, and that abusers are twice as likely to seek sole custody. They are successful in obtaining either sole or joint custody in at least half the cases. And that is the issue that this project is intended to address. Our partners in this project, it's coordinated by the National Council of Juvenile and Family Court Judges. Other partners include the Office on Violence Against Women from the U.S. Department of Justice, the Battered Women's Justice Project, the National Institute of Justice, the Center for Court Innovation. 4 sites were selected for this demonstration initiative. Multnomah County, which is Portland, Oregon, the Family Justice Center in Minnesota, which is Minneapolis, Hennepin County, the Circuit Court of Cook County in Chicago, Illinois, which is today's site, and then the Family Court for the state of Delaware. The project started by a very intense information gathering effort. Stakeholders were convened, documents were gathered, launch events were hosted where the court's systems were all mapped, and then a very intense analysis of each court system was undertaken to identify challenges, contributing factors, and to set priorities. Next step last fall was a planning phase. For a few months, the groups at each site examined their challenges, looked at their resources and their priorities, continued to collect additional data, and made community-specific work plans with activities to help address custody issues in their courts in domestic violence cases. And then the stage that we're in now is the implementation phase. And this phase goes until September of next year. There is a lot of hard work at all 4 sites, continuing to gather data on how the activities are working. A lot of intensive technical assistance from the national partners with the goal of systems change and continued refinement of the activities. And with that, I'll turn it over to Judge Patty and Leslie.
Okay, thank you, Amanda. Good morning, everybody. I'm joined this morning by Leslie Landis, who is the Court Administrator of the Domestic Violence Division of the Circuit Court of Cook County here in Chicago, and also by Stephanie Sanuda, who is the Child Relief Expediter for the Domestic Violence Division. More about her in just a moment. Before I get started today, I do want to express my profound thanks to you, Amanda, and to you, Alicia Lord, with the Council for getting us organized today and providing us with the choreography necessary to conduct the webinar. I thought also I would, without any hesitation, express my profound thanks to our technical assistance providers, Liberty Aldrich and Darren Mitchell, and also, of course, to the U.S. Department of Justice and the Office of Violence Against Women for negotiating in the first instance the technical assistance agreement under which we have been operating for some time now, to our extraordinary benefit, I might add. I thought it might be very helpful to everybody participating in this webinar and for people who might have a future interest in it, for me to detail some of the demographics of the Circuit Court of Cook County so I could provide a contextual background, if you will, for why we examined in the first instance how issues of child custody and visitation are handled by the Circuit Court, and secondarily, most importantly, how we could improve our delivery of justice to the citizenry in Chicago and Cook County. As you all know, Chicago is a huge urban environment. It is but a part of Cook County. There are over 5 million inhabitants in Cook County. I think, in fact, if it were a state by population, Cook County would be the 20th largest in the United States. As a result, we have a very large court system. In fact, the Circuit Court of Cook County is one of the largest court systems in the United States. In Illinois, we have a unified court system, which means quite simply we have on the state side a single kind of trial judge. We don't have police courts, we don't have municipal courts, we don't have magistrate courts. We simply have judges of the Circuit Court. And in Cook County, we have over 400 of them, if you can believe it. So we are dealing with a very large, structured system indeed. And the chief judge of the Circuit Court, Judge Evans, long ago recognized that for the delivery of justice to be complete and appropriate, particularly in domestic violence cases, we needed to educate judges and ensure that they understood the exact language of things related to domestic violence, and that's what brought us to the Department of Justice in the first instance. We have over 10 courthouses in the court system here in Cook County. There are 6 municipal courthouses which hear cases. We have over 1 million cases filed in the Circuit Court each year. And as you can imagine, we have discrete relationships developed with law enforcement throughout the county, most importantly and most obviously with the Chicago Police Department. I think it was about 10 years ago that the county decided to specifically address issues of domestic violence as they were incorporated in the circuit court. To that end, a standalone courthouse related to domestic violence cases was constructed. It's on the near southwest side of the city of Chicago. There are 10 judges housed in the building, and the Domestic Violence Division judges in that building hear the lion's share of the domestic violence cases that are brought in Cook County, all of the city of Chicago, all of the misdemeanor cases in the city of Chicago, and all the civil applications for emergency orders of protection in the city of Chicago. Outlying courthouses hear cases in different suburban districts: northeastern Cook, northwestern Cook, western Cook County, southeastern and southwestern Cook County as well. About 6 years ago, the chief judge, Judge Evans, decided that the best way to ensure the effective delivery of justice in this context was to create and establish a standalone division. And to that end, the chief judge appointed a blue ribbon committee, and the recommendation ultimately was the creation of the Domestic Violence Division, which was essentially pulled away from the Domestic Relations Division. So now in Cook, in the Circuit Court of Cook County, we have both a Domestic Violence Division and a Domestic Relations Division. That has generated some examination, so self-introspection, if you will, by the court system in how we best deal with domestic violence cases. And to that end, that was a part and parcel of our application to Maine DOJ a number of years ago.
So I'm going to talk a little bit about the amount of cases that we hear in the division and so on, just to give you a little bit to hone down on what it is that we're doing under this project within the division. As Judge Patty indicated, we're hearing both criminal domestic violence cases as well as civil independent orders of protection. Just to give you a quick idea of what that means for us, in the criminal domestic violence cases, there is a possibility under Illinois law that an order of protection, while civil in nature, can be petitioned for and heard in conjunction with the criminal charges, which means our state's attorney's office, for the most part, is acting on behalf of the order of protection petitioner when that order of protection is heard in conjunction with a criminal charge in our division. To give you a sense of volume, in 2014, there were over 18,000 cases. These were all misdemeanor cases. 60% of them originated in Chicago. From those 18,000 cases, the state's attorney's office obtained just slightly over 1,200 emergency orders of protection. In Illinois, emergency orders of protection are heard on an ex parte basis for all the reasons many of you are probably aware of. In the criminal court, the focus does move pretty quickly to the plenary order of protection rather than focusing in on the emergency. The plenary order of protection under our law is the final order, and it can last for up to 2 years. And in criminal cases in 2014, in that slightly over 18,000, the state got, on behalf of petitioning victims, just over 4,300 plenary orders of protection. 56% of those originate in Chicago. I want to pause here for a moment and say that in Chicago, we did have a specialized criminal misdemeanor domestic violence court established way back in 1986. We were among the first, if not the first. So there's been a lot of focus locally on criminal prosecution and the reforms that many of us have worked on for years in that regard. But our criminal division is pretty well established, and when our chief judge created the domestic violence division, that all of those criminal cases now are part of the domestic violence division as opposed to a criminal division as they were before. Similarly, the domestic violence division hears all of the independent orders of protection. It's important for you to know by rules of our court that when a domestic relations proceeding or a family law matter, divorce, parentage, that sort of thing, when that is happening, a person can come to the Domestic Violence Division and petition for their emergency order of protection, which our judges will hear. But if granted, that case will be transferred and consolidated to the Domestic Relations Division so that the Domestic Relations Judge is then responsible for conducting the hearing on the final or plenary order of protection. However, that is not the vast majority of the cases that are heard as independent orders of protection in our division. In 2014, again, over 8,300 petitions for independent civil orders of protection were filed in our division, resulting in just over 5,600 emergency ex parte orders of protection being granted, and just over 1,900 plenary orders of protection being granted. On top of that, there were 740 orders of protection cases that were consolidated, as I just described, to a domestic relations proceeding. 359 of those were in divorce, and 381 of those were in parentage cases. The point that we're trying to make here is the vast majority of these independent orders of protection that we do here, there has not been anything previously filed in a family court in a domestic relations action, but for the 359 and the 381 that I just outlined. What's also important for you to know is that 77% of the unrepresented petitioners in these independent order of protection proceedings were in intimate relationships, and of those, nearly half of them had children in common. Our statute, as in many other states, does allow for people that don't fall in an intimate relationship to petition if they have a family or household relationship. I'm saying that of the total here, most of them, 77% of them, were in intimate relationships, and of those, nearly half had children in common. So it's a substantial portion of our caseload here in our division.
And one of the reasons we took a step back a number of years ago to ask ourselves if we were doing the best job in delivering justice to those people who walk through the courthouse doors.
Now, quickly trying to distinguish this, the Domestic Relations Division, or what many people call the family law area, does hear all types of family court matters, including obviously things like divorce, parentage, and child support. They do hear orders of protection that are filed in conjunction with that domestic relations action. So some family law attorneys, when they file for a divorce, also file for the emergency order of protection at the same time. But there are 42 judges in that Domestic Relations Division. It's a substantially larger division than the Domestic Violence Division. And available to those 42 judges are a number of resources that did not exist for our judges in domestic violence hearing independent orders of protection. The things that were available to the Domestic Relations Division included mediation, guardian ad litem, custody evaluators, and parenting classes, just to name a few.
And to be honest, truth be told, before we embarked on the enhancement project, a number of judges here in the Domestic Violence Division were, I will use the word skittish, about addressing child custody issues because of the specific lack of resources available to addressing those kinds of very important issues. And Leslie detailed the numbers of people involved, and they're quite large indeed.
So you heard Amanda tell you about the idea that originated at the Department of Justice Office on Violence Against Women around looking at custody being awarded in cases involving domestic violence, primarily in a family court. So you just heard us describe a domestic violence division, so you might be wondering why OVW included, or why, I shouldn't speculate about OVW, but we speculate, why include the Domestic Violence Division under the Family Court Enhancement Project? So we believe it was for some of these reasons. That many of the victims who approached our division, the Domestic Violence Division, for orders of protection were not married, but they did share children in common with the abuser. There was no intention at the time that they came here, and might never be an intention, to file anything in the Domestic Relations Division. We also found that we also had a process where, prior to even thinking about making this attempt to get this grant, we had a stakeholder work group that was reviewing all the remedies that are available in order protection. And what we found was that there was an illustration that the child-related remedies were not being sought at what we thought would be expected rates. And when they were sought, they were not always being reviewed under the specific standards of our Domestic Violence Act, which we're just going to gloss over in a moment, but we think is significant. And finally, we believe that the goal of achieving safety for victims who were seeking an order of protection was sometimes limited by the neglect of all of us in addressing these child-related remedies.
So just to summarize very briefly, through the aegis of the work groups, we determined that applicants were not seeking all the remedies that were contemplated by the statute in the first instance. And because of that, the court was not even considering, much less granting, relief considering those remedies.
So what we determined was that people were hesitant to really take on those remedies while clearly available under the statute because they were presuming that the standards that applied to the Illinois Marriage and Dissolution of Marriage Act, IMDMA, were those that guided their review of those remedies being sought under the Illinois Domestic Violence Act, or the IDVA. We're not going to go through these next two slides in great detail, but we wanted to provide them to you to just illustrate that the IDVA had some presumptions around against awarding custody to people alleged to be abusers, that one incident could be enough to trigger that presumption, while under our Marriage and Dissolution Act, there was no rebuttable presumption about awarding custody to abusers, that there was a guidance around maximum involvement, many of you are aware of these things, and that unless there was ongoing or repeated abuse, that maximum involvement of both parents was presumed. There was also a presumption that there was a presumption under the Dissolution of Marriage Act that there would be reasonable visitation. No such presumption exists under our Domestic Violence Act, and in fact, there's some very specific language in our act around restricting visits. Under divorce law, you could only restrict visits under the standard that it would cause serious endangerment of a child. Under the Domestic Violence Act, it is that the respondent would likely to abuse or endanger the child, or significantly, I think, distinguishing that the visitation can be restricted if it's likely that the respondent will harass the petitioner. That is not a consideration in divorce as heavily as it is under the Domestic Violence Act. And the remedies had different rules related to evidence. But we don't want to spend a lot of time on this except to say that what we found was there was a lot of confusion around what was the standard, what was the remedy, which we were supposed to be using, and so on.
In short, we had a situation where we had different and sometimes competing standards between the Domestic Violence Act and the Divorce and Marriage Dissolution Act, and that was a confounding issue for us in examining how issues of child custody and visitation were addressed in the Domestic Violence Division.
So early on and through our planning processes, we found that we were faced with a number of challenges. And just quickly trying to summarize these, we knew that victims who really wanted the other parent to continue to have contact with their children weren't always being provided that opportunity. As the court generally viewed the instance where a victim might ask for visitation as an indication that there really wasn't an emergency, that if they thought that contact was okay between their children and the other parent, that perhaps the need for this emergency protection that didn't include a no-contact total stay away was not founded. That children who might have been able to see a respondent parent in an unrestricted or restricted way were virtually unable to have any contact at all, and that victims were not returning to court sometimes after an emergency order of protection. We speculated that we thought that that might be in part because we were not paying sufficient attention to issues related to their shared children. We also found that litigating attorneys, even those that we thought had the most experience in domestic violence, were not always utilizing the IDVA arguments that we just discussed to the fullest extent when making their case in front of our judges. And advocates definitely did not understand the nuance of these arguments between the Illinois Domestic Violence Act and the Illinois Marriage and Dissolution of Marriage Act. in order to help their clients understand that and seek proper legal strategy. We also found that prosecutors here at the Domestic Violence Court remember that the order of protection provides the same remedies, whether that order of protection is sought in criminal court or civil court. But what we found was that prosecutors were not really interested in litigating issues related to children when they were seeking orders of protection on behalf of a complaining witness in a criminal case. And public defenders, quite to our surprise, weren't particularly interested in these issues on behalf of their clients, who were often fathers of these children in common with petitioners. Judges were also reluctant to grant these remedies. This is what Judge Patty was just referencing, as there was sometimes a view that victims who were seeking that kind of child-related remedy in an order of protection were doing that as a subterfuge for filing a domestic relations custody case. And our judges believed that those judges were better situated in seeking, in having resources available to them to aid them in their decision making. We also realized that there was what we perceived to be kind of an underutilization of orders of protection in divorce and parenting cases, which we thought indicated that most family law attorneys in the Domestic Relations Division were not utilizing orders of protection or the IDVA standards, which might have benefited their clients on issues of children as a preliminary matter in the early parts of a divorce or parentage action, which finally led us to the conclusion that the staging of permanent versus temporary legal relief for a victim parent at the point that they would be seeking protection from abuse was not known or understood by litigants or many of the helpers or some of the decision makers. So how that fit into their overall goal of seeking safety wasn't always understood.
So what did we do?
So we discussed all these challenges with our stakeholder group and applied for the Family Court Enhancement Grant in collaboration with the Domestic Relations Division. So we didn't go at it alone. We recognized that the intersections between domestic violence and domestic relations divisions were certainly something we were going to have to be attentive to.
Let me stop just for one brief second and emphasize the cooperation of Domestic Relations Division, because I think it's important, certainly from our context, for everybody to know that this was a joint collaborative effort. Very early on, Judge Grace Dickler, who was my predecessor here in domestic violence, is now the Domestic Relations Division presiding judge. She's been actively involved. We've had her active participation and collaboration. She attended the All Sites visit in Minneapolis here earlier this year in April, but for her cooperation and collaboration, we would not have made the great progress that we have made to date.
So we were exceptionally delighted that we were selected as one of the 4 jurisdictions that Amanda outlined, and we continue to build on our history of collaboration. Judge Patty's going to tell you a little bit about the collaboration. Who's on it?
Okay. We early on established a collaborative team, and a subset of that team we called the management team. Larger group, smaller group. From the larger collaborative team, we had participants from, obviously, the judiciary. We had nonprofit legal service providers and advocates who participated as well. The Office of the Public Guardian, the local bar association representatives were present. We had the clerk of the circuit court representatives, as well as the Cook County Sheriff's, CPD, the Chicago Police Department participated as well. Members and employees of visitation centers were engaged. And we had, how many total meetings did we have?
Oh, I don't know.
A number to assess where we were and where we needed to go, once again to bring this back full circle, to provide the best provision of justice to litigants who came in this building.
We were very fortunate to have the Center for Urban Research and Learning of Loyola University join us as our local researcher, and they've been helping us all along the way, and we're going to talk about that towards the end, but we're happy to address anything that anybody would like to know about that.
They have basically been our recording secretary, if you will, throughout the entire process.
And helping us to figure out what data to collect and how to analyze that data. So that group had to come together, and what may seem like a very interesting process, what it really was a very arduous process with lots of meetings and lots of debate. You can imagine with a room filled with those people what that would look like. But we had to land on a logic model or a local work plan, as Amanda referred to it. And here was some of our basic logic models, and I have to tip my hat here to Darren Mitchell and Liberty Aldrich for their big-time heavy lifting to help us to get this, to illustrate the vast conversation that occurred among the various people.
In short, again, what they did was to synthesize and specifically define programmatic issues of an overarching definitional mode that allowed us to review what we were doing so we could project what we should do, once again, in the context of the delivery of justice.
Okay, so I want to get into some of the specific activities, but quickly, our logic model challenges were that we had a disagreement about the appropriateness, the range, and the information required to deal with child-related relief and plenary orders of protection. We knew that the information needed to make informed decisions about child-related relief was not available to the decision makers, and that's not just limited to judges, but others who help make decisions along the way about how a case is processed, all the practitioners and the parties. That we had hurdles presented to us by the existence of two separate court divisions that issue child-related relief in cases involving domestic violence, as well as the separation of criminal and civil cases within our division itself. And we knew that that was preventing some victims from getting the child-related relief that we knew they might be entitled to. So we're going to go through some of our strategies and activities. First of all, we really began by trying to focus on how we might identify cases involving children in common where the need for that kind of relief was part of the safety under the orders of protection. As I said, we weren't really seeing petitioners ask for it. We recognized that they might not even know it was available. But more importantly, we did have to engage in a facilitated discussion with our criminal court because there was even less activity related to children in orders of protection being heard in a criminal case. And that was a very interesting process in that it involved our prosecutors and our public defenders, our advocates, and some legal aid type domestic violence lawyers and so on. And what we found was in engaging in that discussion that there were a lot of genuine considerations for a prosecutor about whether or not to seek that relief and have it result in a contested proceeding right in the middle of a criminal prosecution, a contested custody proceeding or contested proceeding related to visitation, right in the middle of their underlying criminal prosecution. The public defender's office wasn't keen on having those things heard, and the public defender's office frequently agrees to the entrance of a plenary order of protection. Had the state started asking for lots of relief related to children, there was the idea that the public defender might cease to agree, resulting in contested hearings, disrupting the criminal proceedings, and so on. However, our statute does provide that those remedies are available to petitioners having their order of protection heard in a criminal case. So we're still working on the balance there of how you allow full access under the intent of our statute to those remedies, irrespective of which venue the petitioner's case is heard in, and how that affects the criminal prosecution. What we're looking at very quickly, I just want to spend a minute, is that our prosecutors have begun to screen more effectively for that and ascertain what priority those remedies might represent for their complaining witness, order of protection petitioner. If it is a priority, there is some agreement that they will include those remedies in the order. But if it becomes contested, what we're looking at is fashioning a response that might bring a civil attorney in to handle making those arguments and possibly reserving that aspect of the order of protection hearing to a different date. Those things have not yet happened, and they're under review and continued discussion, but we think we've made some real progress in that regard.
Just to summarize very briefly, we were presented and ran headlong into the following. State's Attorney Public Defender taking the clear position, we've never done this kind of thing before. We don't want to do it now. It's the civil practice of divorce law. We have no interest or involvement with that whatsoever. As opposed to, well, the statute authorizes it. If it doesn't compromise in any form or fashion your criminal prosecution, why not at least consider it?
So that was one big piece, and that's still an ongoing conversation, and it's unique to our jurisdiction, so we really are trying to put a lot of effort into that. The next thing that we did was, when petitioners come into our domestic violence courthouse, they check in at what we call our help desk. These are employees of the presiding judge's office, and we get some basic information to make sure people are in the right place at the right time and so on. We've added 4 additional questions to some information that level of personnel was collecting, and under the grant we were able to hire an additional position for that effort. And when those additional questions related to children are asked, that individual does a triage link by giving an alert. It's a form that we call our alert form that accompanies that victim. If they're being screened by the state's attorneys for possible charging, the help desk has alerted the state's attorney's office that child-related relief is a concern to this victim so that they do better screening on it. But more importantly, the vast majority of those cases are the alert card accompanies that victim into our domestic violence legal clinic, which is a legal service provider that is housed here. I'm going to talk about them in a minute. They then review the fact that this is a potential FCEP case. In addition to that, just on the strategy of identification of cases, we have conducted litigant focus groups, and we have found that in those focus groups, many of the litigants, the victim litigants, told us they had no idea this remedy was available, and the few that did and got it, the ones who didn't and didn't ask for it and didn't get it, were disturbed that they didn't know. So we really know that we have to really do a much better job at getting information to those petitioners. We're planning a December focus group with victims who opted not to get an order of protection, hosted by one of our domestic violence shelters, so that we hope to learn to what extent the children were a factor in that decision not to seek an order of protection. The next strategy that we want to spend a little time on was that we decided that we needed to increase legal representation for self-represented victims and develop best practices in dealing with pro se or self-represented court calls. Because the collaboration identified the fact that lawyers were not always fully utilizing the Domestic Violence Act standards, we funded one FTE, full-time equivalent attorney position under this grant, and it's housed within the Domestic Violence Legal Clinic, which, as I said, is a nonprofit located in our building. And when those alert cards from that front desk go to the agency, that attorney participates in that agency's case acceptance review. We're tracking the very specific strategies and outcomes on the cases handled by this FCEP-funded attorney. And when her caseload precludes her from accepting a case, we are also linking those extra cases that the help desk identified to pro bono attorneys and law student resources, as well as advocates, and our local researcher is tracking all of those outcomes. We established a legal services provider committee to review and discuss this project because we knew that one lawyer wasn't going to be able to make a big difference. We're just following her application of specific strategies related to using the Domestic Violence Act standards. But we wanted to expand that to the larger legal service community, so we developed a legal service provider group, and they've been engaged in the review of many of these items, and they are the group that is willing to consider stepping in on those criminal cases when an order of protection includes contested child-related relief. That is a work in progress. There are plans to train lawyers and advocates as we gain greater insight on best practices and their role in helping to ensure that we achieve a common understanding. I'm trying to fly through some of this so there's time for questions. I think the last strategy that we highlight, I'm not sure about that. Yes, the last strategy that we highlight is that we wanted to examine what information was available to judges and other professionals and litigants which inform decision-making at the various stages.
So to that end, we surveyed both the Domestic Violence Division judges and the Domestic Relation Division judges. We had 100% cooperation with the DV judges and a very good response rate from the Domestic Relations judges. And in short, what we found out, quite simply, was there was a gap between the information that the judges believed they needed to make a factually sufficient and legally appropriate determination in a child-related decision, and what they actually had in terms of resources to make that decision in the first instance.
For example, our judges, we found that they often had to rely only on the testimony of litigants, and many of these litigants were self-represented. They didn't even know what the standards were that the judge was looking for, and often were not able to put that information in front of the judge. We also found from our judges that they didn't have benefit of knowing information that the court did know, such as the history of litigation between the parties. Sometimes they get it, sometimes they don't. Often the only source they get it from was the parties. And we also found that judges seemed to question the credibility of some of the litigant parents who sought child-related relief. Really, it was about the motivation of that parent in seeking that relief in an order of protection as opposed to a child custody proceeding, as we discussed earlier. Interestingly, despite the fact that the questions were asked in demarcated fashion when making child-related rulings under the Marriage and Dissolution Act and the Domestic Violence Act, we found that the domestic relations judges made few, if any, distinctions. We asked those questions separately. What were they looking for? What did they consider? And their lens remained the Marriage and Dissolution Act primarily, so that the intent of connecting the context of domestic violence to the safety of the victims in need of child-related order protection remedies, we felt was not adequately understood, or at least it wasn't applied consistently, if at all. The supervised visitation and exchange centers were not being used by our Domestic Violence Division. They were being used by our Domestic Relations Division. And knowing that what we know about separation, violence, and risk, we entered into a discussion with the centers about taking these cases, earlier intervention point, and that might influence whether or not that was necessary over the longer term. We also began looking for tools to help the litigants and the court whenever possible to come to an agreement on how custody and visitation in any context would take place, and that led us to the Child Relief Expediter. We could both do this.
Sure. Well, it was a clear need in terms of a basic position. It was a clear gap in what the judges believed they needed to complete the delivery of justice in the context of child-related relief. So we put together a position description. We called the position Child Relief Expediter. We provided a detailed background of the description of the job, the duties entailed, and the protocols that we were anticipating for use by the expediter. We have put together a script, if you will, for each judge to use when there's going to be a referral to the expediter that makes clear that the referral to the expediter is a completely voluntary decision by both the petitioner and the respondent, that it is going to be conducted, the proceeding will be conducted in a confidential manner by the expediter, that either party can withdraw the consent to participate at any time for whatever reason, and any child relief remedy will be addressed by the court itself rather than the expediter. And at least in the first instance, any discussions with either party will be conducted on a shuttle diplomacy method, if you know what I mean by that.
there was a lot of discussion around the idea that the expediter would not be making recommendations to the judge and would not be making any findings or helping the judge in making findings related to the existence or non-existence of the abuse. That the expediter's role is to facilitate, if you will, if possible, on a shuttle basis, the negotiation of custody and visitation arrangements, primarily visitation arrangements.
This is in no form or fashion to take away the responsibility of the court for making those kinds of important decisions. Rather, we are intending to provide to the court a mechanism that will assist the court in these kinds of important decisions, and to the benefit of the individual litigants, assist them in resolving these issues more quickly than opposed to lengthy court hearings.
I was remiss in not saying that there was a lot of historical work here in Cook County with mediation as a division in the domestic relations division of our circuit court. The domestic violence community has worked long and hard with mediators so that they do understand, properly screen, are very domestic violence aware, so that when we approach this concept of a child relief expediter with our legal aid community and our advocacy community, they were perhaps a little more comfortable with the idea of that being applied in some instances of cases involving domestic violence based on positive experiences that they had had with mediation in divorce and custody proceedings, where that was done with absolute mindfulness about the existence of domestic violence and possible coercion. So that philosophy is carrying through to all that we're doing related to this child relief expediter.
We're hoping for a launch in December. In terms of possible outcomes or results from the expediter, we're anticipating that best case scenario, we could have a complete agreement whereby the petitioner and the respondent agree to a Monday, Wednesday, Friday visitation regimen, to put in the context of a visitation context, a partial agreement where the parties are able to agree to Monday, Wednesday, Friday regimen, but there's a disagreement about a location or a possible person to facilitate the visitation, in which case that discrete element would be referred back to the court for disposition. And finally, no session occurred result, which is a neutral way to encapsulate what did or didn't happen before the expediter.
So when somebody gets linked to the expediter, after they've done a questionnaire with each party individually, they can determine that the session will not occur. That could happen for any number of reasons. It could relate to something about the potential risk to the parties. It could relate to the fact that the petitioner didn't understand that she could opt out, even though the judge said it was voluntary. Any number of reasons, but the session not occurring will be reported back to the judge, or a partial agreement, or the agreement.
We are very mindful of the level playing field aspect that appertains to issues, very often appertains to domestic violence cases, and we want to consider that element as well. So
finally, of course Stephanie is here, so if there are questions you could ask her, but the other thing is that we wanted to take a few minutes and let you know what we've done with our judges. That our domestic violence judges have received training on those varying standards, so that we're really trying to highlight what was at the crux of their deliberation as it relates to standards. Then we tried to educate or inform them about how the risk factors, many of those that are familiar to you all, should help the judge in their fact-finding on child custody and visitation issues. They knew how to factor risk into decisions related to bond or sentencing, but it was a new concept to think about those risk factors as it related to their fact-finding on child-related remedies. The judges were urged to look at the context and the inferences that might be drawn from the existence of domestic violence or the prevalence of risk factors in a specific case, and we did that using the Battered Women's Justice Project analytic model, which I suggest that anybody who hasn't seen it might look at it. That the judges reviewed procedures, and we had them review the procedures and that we had created around the use of the expediter, and we've received their feedback, and we're now incorporating their feedback into the operations before we launch. In 2016, we're planning a follow-up training, which will also introduce the use of, bring them into the room in presence with the judges, the use of supervised visitation and safe exchange centers. And a number of our judges have participated in the Council's Enhanced Judicial Skills Training. So the last couple things we just wanted to point out was that key to all of this, I mean, in order to make sure that our petitioners even know that those remedies are available, we kind of have to get upriver. We put a lot at the back end, and now we got to get to the front end again and really start developing petitioner brochures or guidelines or information that can let somebody know at the point where they're actually seeking their emergency order of protection that they should begin to deliberate about these issues related to children, and that there are resources available to them to gain further information about what might be possible in that regard. That is a big piece of our undone, yet to be completed work. The two items that are asterisked were things that were not done under grant specifically, but they are stand beside and conducive, complementary resources that we have developed. Through very generous private funding, one of our supervised visitation centers has been successful at obtaining some funding that will allow a full-time position to be housed at our courthouse that will serve as a liaison for the litigants to talk to if the use of a supervised visitation and safe exchange center is being contemplated as part of their agreement. So that position will be able to feed individuals to any one of the several supervised visitation and safe exchange programs that exist in our city. That contact could be made before the litigants leave the courthouse. Additionally, we have developed a respondent video. It's in the final throes of completion, thank goodness, and it is intended to be used for the judge to order the respondent in civil orders of protection to view it before he leaves the courthouse. It basically tells him what he has to do to observe the order of protection fully, and talks about the harm that his abuse has had on his children and how he might do things differently. And at the end of the video, the respondent takes a quiz and a certificate is printed, so that we at least get one attempt at getting some further information in the hands of the respondents in civil orders of protection before they leave.
English and Spanish.
Everything is in English and Spanish, I'm being told to say by Judge Patty. Last of all, next steps. We recognize that we really need to continue our community discussion. Everything is being reviewed, and we're seeking input and feedback, and boy, are we tired, from all of our collaborative and management team members. We're gearing up to do all kinds of additional training, and perhaps most importantly are these last two items. We're now finally going to turn our attention fully to the idea of the intersection between our domestic relations and our domestic violence divisions, when transfers should be made, should we be looking at some rule changes, and so on, how to make those two divisions work in concert even better than we do now. And last of all, we're working with our local researcher. We're really looking at outcome and data review. As Stephanie starts the expediting services, as Judge Patty said, in the next week or so, then we really are going to start collecting some concerted data on her services. We're already getting data from our legal aid attorney and a number of other sources that are all being put together and looked at with the help of our local researcher.
That basically concludes our presentation. I'm really hopeful that we have some questions. I think we have about 10 minutes left, maybe less than that at this point. But I'd be happy, Leslie would be happy, Stephanie would be happy to field any questions anybody has about process, procedure, and next steps.
While people are typing, I will just say that this has been a really interesting and thought-provoking exercise for many of us that have done domestic violence work for a long time. It really brings into light how these intersections are of great importance to people who are seeking protection from our division. And it has resulted in some very interesting discussions among those of us who work in this building, not always in agreement.
Quite animated sometimes.
So that, to me, that illustrates that best practice is still being formulated and can be informed over time, which is why we're so grateful to OVW in supporting these efforts. We're reading a question. Should we read the question or can people see it?
Go ahead and read it.
Aaron asks, how would you both describe the balancing act between fact-finding / needs assessment and implementation? That is, understanding the nature of your challenges and piloting new approaches to achieve the right balance.
Well, we try to keep, I'll start, if I understand correctly, we try to keep the fact-finding in the hands of the judge. We try to, I'm not sure I'm understanding the question exactly, but
I think it might be a little broader than that. I'm interpreting fact-finding as introspection when we created the management team and the collaborative work group in assessing the delivery of justice within the circuit court, and now understanding system challenges. Yes, I think we're on the same page with Aaron at this point. Well, therein lies the rub. I think what we did early on was to put in place a mechanism by which we could gather the facts to assess what we were doing and how we were doing it, to take us to the next level of examining the kinds of things we might think about in talking with the state's attorney, in meeting with the public defender, in addressing these issues with the clerk of the circuit court and the sheriffs. You know, everybody has a piece of has an important piece of the puzzle to make sure that the system as a system works efficiently and effectively. And now we are at the next step, the last slide on the PowerPoint, to determine what we need to do from here and how we need to do it to ensure that the ultimate goal that we set for ourselves way back when is achieved.
I can tell you that prior to the grant, there wasn't we had discovered that we were not doing the greatest job on these remedies, but there wasn't an infrastructure to really advance that dialogue among and between the various people that deal with both victims and abusers in this building. So I think what has been provided to us was an opportunity to really focus those discussions in a productive way, allowing us to implement some things and experiment with those things, using a researcher to help us evaluate it, and none of that would have happened absent OVW support and technical assistance.
That's absolutely true. And I mentioned this to Leslie the other day, and I think we both agree. To some extent, we're a little bit of a victim of our own success and our own foresight. And by that I mean, while I'm aware of the fact that this is one of the very few standalone courthouses in the United States of America that deals with domestic violence issues only, there's always a better way to deliver justice in a fair and neutral and dispassionate kind of way. And the grant gave us an opportunity to specifically address that and look at the statute and say, well, the statute authorizes all these different kinds of remedies. Are you really doing the best job you can? So it clearly allowed us to do that.
we're being asked about how the DD advocates influenced this, how we engage them, and how they changed our sense of litigant experiences and how they impacted our project priorities. I would say the advocates were front and center on a lot of this dialogue. They've really pushed for the idea that child-related relief was an essential part of the goal for many victims in obtaining protection afforded under their orders. I think they did share with us litigant experience, but the truth is that at the point that we were really looking at this, the generalized practice here was, and everybody was doing this, was to not address these remedies. So there had become sort of this soft neglect. And I think that was true of everyone, including the advocates. Now, why that is historically might be based on negative experiences. You don't ask 100 times and get yelled at for asking and not stop asking after a certain point. There's an ebb and flow to that, but I think that they're excited because it's opening up the possibility to really fully address what they've always known to be a gap in our division when it relates to children. So I think they've really helped. I think the legal service providers even more significantly informed this, and they are DV advocates as well. So they're continuing to be engaged with us. They've looked at everything, including even the Expediter job description. They've had input all along the way.
Hey, we have one person typing, but we are at time, so let's give a second here and just see if we do have one last question.
Okay.
I don't want to cut anybody off.
I give shorter answers when I see more questions.
Okay, he just said never mind. Okay. All right, well, thank you very much, Judge Patty and Leslie. Great job this morning. Thank you, all the participants. Please stay on the computer for the survey link, and thank you again.
Well, thanks to everybody, and happy holidays.